Welcome to the Canadian Intellectual Property Office and our webinar on clean tech and intellectual property. This is a pre-recorded webinar that will take 50 minutes to complete. The start time for each section is indicated on the screen, so you can skip, stop, go back, or repeat as you wish. First, I will introduce you to the Canadian Intellectual Property Office, CIPO, and briefly explain what we do. Then, I will outline some of the key observations in the Canadian cleantech industry and explain why IP is important. If you are unsure of what IP is, I will cover the fundamental concepts in Section 4 before we walk through 6 steps to develop an IP strategy in Section 5. This section also includes some examples and resources specific to developing an IP strategy in the cleantech industry. In Section 6, I will explain some of the key considerations to protect IP during collaborative research and development. Finally, we will wrap up this webinar by guiding you to our additional resources for our IP awareness and education that are available in Canada free of charge. The Canadian Intellectual Property Office, CIPO, is part of the Government Department of Innovation, Science and Economic Development, Canada. CIPO is a special operating agency, and we are responsible for the administration and processing of the greater part of intellectual property, IP, in Canada. Our operations are funded through IP fees. At CIPO, we examine and grant IP rights such as trademarks, patents, and industrial designs. Based on various laws and regulations, we provide a quasi-judicial function for trademarks and patents. We also have a mandate to raise awareness for the effective use of IP. We provide a range of products and services free of charge to help Canadian companies gain a better understanding of the importance of protecting and managing their IP assets. We also share IP information in, for example, online databases to support innovation. And finally, we make sure our IP systems are similar to those in other countries so that we can support businesses that operate globally. What do we mean by clean tech? In this presentation, we will use the definition used to identify patents in this space, and then we say that clean tech is any technology that either helps resolve or mitigate environmental impacts or conserves the natural environment and resources. Clean technologies are important for Canada's economy. In the past, 3% of Canada's GDP was attributed to production of clean technologies, clean energy, waste management, and environmental goods and services. Canada's cleantech production extends beyond our national borders. Over 17% of Canadian clean technology production in 2016 was exported. Looking forward, our clean tech industry continues to take on the role of a global leader and is well represented internationally. In fact, not less than 12 Canadian companies were featured on the 2019 Global Cleantech 100 list. This is a list of companies identified as likely having a significant impact over the next 5 to 10 years. Our innovation system in this sector is backed up by a strong research system. Our researchers represent over 3% of the sector's academic publications globally. Canada recently ranked as number 4 after Scandinavian counterparts on a 2017 Global Cleantech Innovation Index, which ranks countries by their potential to produce entrepreneurial cleantech startup companies that will commercialize clean technology innovations over the next 10 years. Our skilled and entrepreneurial workforce is also supported by the Pan-Canadian Framework on Clean Growth and Climate Change, which will encourage the development and adoption of clean technology. The sector is faced with a few but significant challenges. Most of these relate to the commercialization of our research. We have risk-averse consumers who are slow to switch over to new technologies. Stakeholders have also highlighted that we need stronger policies and regulations which can increase the domestic demand. For example, many clean technologies are hard to compare because there are still no standard ways to measure and compare their performance. Finally, even for technologies that have reached the market, there is limited access to finance for scaling up. As we just saw, we have a strong innovation system with big potential for growth. We also saw that it's difficult to commercialize and scale up our clean technologies. Many of the challenges, such as policy, standards, and risk-averse consumers, are often outside the scope of control of our innovators. But let's turn the focus to what we can control, our intellectual property. Innovation is a big investment that needs protection. It all starts by identifying your IP. Make sure to seek formal IP protection and know how this is done. Use IP to create solid cornerstones for how you will commercialize your invention. For example, in some instances, you may want to seek IP protection for your inventions as soon as they are invented. This will make it easier for you to discuss your invention with others without fear of losing your IP rights to copycats. As you will shortly learn, clean technologies can access a fast-track route to patent examination. We will also introduce platforms that make it easier to find and use others' IP. Steer your efforts. Develop an IP strategy so that you have a plan for how to use your IP in order to achieve your business goals. This is also a good tool for communicating with and convincing investors. In the next two segments, you will learn about the different types of IP, as well as how to develop an IP strategy. Holding formal IP has shown to be a strong indicator if a company is likely to export, experience high growth, and seek finance. Let's look at some of the differences between companies that have no IP and those that hold formal IP. In a 2017 survey, some Canadian SMEs without formal IP indicated that they're likely to export, be high growth, and seek financing. Interestingly, the group of Canadian SMEs that have formal IP were 4 times more likely to export, twice as likely to experience high growth, and 27% more likely to seek finance. Do you have IP? Visit our website to learn how you can identify and protect your IP on www.canada.ca/IP for business. Much of the world's economy is taking on a shift towards an idea economy. This means that much of the economy is based on ideas rather than tangible assets like factories and raw materials. These days, up to 90% of the market value of a company can come from intangible assets, such as brands and the intelligent designs of hardware and apps in smartphones, new medicines, online platforms, and so on. The use of IP among Canadian cleantech companies is low. Only 32% hold registered trademarks, 24% hold trade secrets, and 21% hold patents. Use IP to turn your idea into an intangible asset. By learning what IP is, you'll be better equipped to identify your own IP and secure formal IP rights. A trademark is simply a sign or a combination of signs that helps consumers identify your product and services by distinguishing them from others in the marketplace. In most cases, a trademark consists of words or letter combinations and specifically designed logo and also the letters for a domain name, for example, www.company.com. More recently, trademarks have been expanded to also include tastes, textures, moving images, and many other features that make a brand or product stand out. In terms of branding in cleantech industry, green or eco branding could be used for electric vehicle charging, low-emission vehicles. There are various types of trademarks. One particular type of trademarks is called certification marks, such as the Energy Star, which can also be used when certain conditions are met. When you register your trademark in Canada, you have the sole right to use it in association with your products and services. Protection is valid for up to 10 years and renewable every 10 years. You don't have to register your trademark. By using it for a certain length of time, you may have the rights under common law. However, if a trademark is key to your business brand and identity, it makes sense to register it, which gives formal protection and the sole right to use the trademark in association with your product and services in Canada. Canada recently joined the Madrid system, which means that you can apply for trademark protection in more than 100 countries by filing one single international application in one language with the World Intellectual Property Organization. If you're thinking about registering a trademark, search in our databases to make sure the name isn't taken first. Also, make sure you know under what kinds of goods and services you want to register your trademark. When applying for trademark protection, you may either file on your own or hire a registered professional, a trademark agent. CIPO's website offers a list of registered trademark agents in Canada. The next form of IP we'll look at today is the patent. This is a legal right granted by a government for rights to an invention that must meet 3 requirements. These are 1. It's new, a first in the world. 2. It's useful. It solves some problem in a practical way. And 3. It's not obvious. In other words, something that is not apparent to a person with ordinary skills in the field of the innovation. You can patent products, processes, machines, and chemical compositions, as well as significant improvements to an existing patent, provided that it meets the 3 requirements. After a process of examination by CIPO, a Canadian patent may be granted with a duration of up to 20 years from the date the application is filed. The patent allows the holder to exclude others from making, using, selling, import, or export of their invention in the country or region where the patent is granted. If the examination finds that the invention is not new, useful, and not obvious, it would most likely be rejected. Part of the application process requires the person applying to fully disclose the invention, including how to make it and how it operates. This information is made public 18 months after a patent application is filed. So, if you have an invention that involves an important element that is currently secret, you'll want to carefully consider your options for protecting it, either through a patent or by keeping it a trade secret. An invention should not be disclosed to the public before an application is filed, or it will be considered in the public domain, or what we call prior art. There is an exception to this rule in Canada and some other countries, including United States. The inventor may file an application up to 12 months after they first disclose the invention without losing the rights in these countries. There are many ways to apply for a patent protection in other countries. You can apply either directly to the patent office in your target country or file an international application through the Patent Cooperation Treaty, PCT. Regardless of how you apply, it is the receiving country that will examine and issue your application based on local laws and regulations. Next, we'll look at copyright protection. Copyright protects original creative works that are literary, dramatic, musical, or artistical in nature, such as a book, play, music composition, or sculpture. Other examples of works that are protected under Canadian copyright law include motion picture films, paintings, drawings, photographs, web content, and communication signals. Software is also subject to copyright as literary work. Some data could also be copyright, for example, oil sands data, carbon capture data, energy or tidal data. Copyright gives the owner exclusive rights to reproduce the work it protects. It also covers the right to publish, translate, and to perform it. Copyright protection is automatic. Unlike industrial designs and patents, which you must apply for, copyright exists automatically from the time your creation takes a form. But you can, if you wish, obtain a formal registration with CIPO if you want an official certificate of ownership. This only costs $50 online and it's easy to do yourself. So if the day comes that you go to court over a copyright matter and you have a certificate of registration, The onus of proof would be on your opponent. Copyright in Canada generally lasts for the life of the creator plus 50 years. Unlike other forms of IP, copyright is generally recognized globally through the Berne Convention. For example, if you created the content and images for your website in Canada, most countries recognize those rights. Different jurisdictions recognize copyright for different durations of time. Perhaps the most underutilized of all IP rights is industrial design. But this is changing worldwide. The use of industrial designs has doubled since 2005. In the US, industrial designs are called design patents. Industrial designs are the novel, decorative, non-functional part of a mass-produced finished product. They can refer to the shape, the pattern, or the decoration of the product. The whole idea of an industrial design is that it must be original and appeal to the eye. It could also include software elements, such as display screens, and an original graphical user interface. A registration grants the exclusive rights for up to 15 years, meaning you can defend your design against infringement for up to 15 years. To maintain the exclusive rights for its complete duration, a maintenance fee must be paid. Like with patents, designs should be kept secret until the registration process begins, although Canada does permit disclosures up to a year before an application is filed. Just like patents, industrial design rights are national, and you would have to seek registration in all of the countries in which you're planning to do business. You can now use the international route of the Hague system. Through this system, applicants can apply for industrial design protection in multiple countries through one application and pay fees in one currency through a single transaction with the World Intellectual Property Organization. A trade secret is something that is confidential and has value to your business as an intangible asset, such as business information that can be valuable if kept secret. It could be data, algorithms, know-how for chemical process, or manufacturing. As mentioned before, a patent requires full disclosure of the invention in order to get exclusive rights to it. A trade secret is, of course, the opposite. You must keep it totally secret to maintain the maximum value. There is a risk to be aware of, though. If someone independently invents or replicates your secret, you'll lose the competitive advantage. There is no application or registration process for a trade secret, which means that there are no formal rights, so you'll want to guard it closely. An invention that is kept secret may ultimately be disclosed if the owner decides to apply for a patent or other form of IP protection. This is a decision to be taken carefully, weighing in the cost and benefits. It's a good idea to protect your trade secrets by recording their existence, track the names of the people who have access to them, restrict your distribution of trade secrets through confidentiality agreements. Keep the information locked and encrypted. First, let's define what we mean by an intellectual property IP strategy. An IP strategy is a document where you describe the plans and actions you will take to maximize the value of IP to achieve business objectives. In short, an IP strategy is simply a plan outlining how you will use IP assets to reach your business goals. This is a strategic document similar to your marketing strategy, HR strategy, finance strategy, and so on. As the next short segment will show, recent statistics indicate that many companies, even those that hold IP, don't have an IP strategy. It's an underutilized tool. Between 30 to 60% of Canadian small to medium enterprises know what IP is. However, only a small part of Canadian companies actually use IP, often less than 10%. Intellectual property can be valuable, so having a plan and budget for how to use it is important. But when we investigate if companies have a plan for their IP, we see that only 9% of companies that innovate have an IP strategy. If you're ready to develop your own IP strategy, visit www.canada.ca/IP for Business to learn more. Now we will explain the 6 steps to develop an IP strategy. Here's an overview of the steps, which we'll go through in more detail. I'll also give you examples on tools related to IP for clean technologies. First, you take an inventory of the existing IP assets you have. This is what we call an internal IP audit. The second step is called an external IP audit. This is when you take a look at the companies and stakeholders your industry is made of, identifying their IP that may affect your business. Third, you analyze this landscape along with your own IP audit findings to identify gaps and opportunities. For example, you may find that you need to secure more IP rights, in-license IP from others, divest from some IP, and so on. Then you proceed to create your plan. The goals and actions in the plan depend on the type of IP strategy that you've decided to rely on. You will learn more about IP strategy types. The 5th step is to implement your IP strategy. For this, you will need some basic policies or frameworks to effectively manage your IP strategy. For example, the IP strategy should be communicated to the relevant people within your business so that they can support your actions. Finally, the development of your IP strategy is not a task that you complete once. As market and technologies change, so do your business goals, and so you will need to continuously reassess and realign your IP assets with your new goals. So by going through these steps, a company will have a good sense of what they need to do with their IP to support their business. Now we will go into more detail for each of the above steps. An IP audit is when you take stock of your IP. If you're feeling unsure of what IP you possibly may have, go to our website and download our intellectual property checklist. This list gives examples of IP such as names of goods and services, packaging, websites, and explains what category of IP they may fall under and how these can be formally protected as IP rights. An IP audit is an important exercise often carried out by a team that has legal, competitive, and technology skills related to your business. Here are some of the questions the team will need to answer about your IP. Who owns the IP? Confirm the ownership of your IP assets and that you have contracts to avoid IP-related issues. If you're receiving funds to, for example, do research and development, it's also important that you understand if your sponsors can make legal claims to the results of these activities. Are there any restrictions? Similarly, if you are partnering with other people or companies, know if these partners can claim or already have rights to your IP assets. What are the geographical markets? At this time, it's also useful to consider the locations where you might do business, such as conferences, sales, manufacturing, assembly, and so on. Finally, think about your core business and what makes you unique. Why do customers choose your product or service? How are you different to your competition? Most importantly, is the IP protecting these key differentiators? Next, you'll proceed with an external IP audit to identify key IP in your industry. This is sometimes called landscaping. Look for IP information on your competitors' websites, press releases, articles, scientific publications, and of course, databases of existing IP rights, such as trademarks, patents, and industrial design databases. Often, much of this information is available to the public online for free. Getting an idea of others' IP will help you understand your own IP position. Maybe someone has already registered a trademark you are planning to use for your next big idea. When you know about others' IP, you can avoid spending time and money trying to protect your creation only to realize it can't be protected. You can also avoid lawsuits if you're infringing on someone else's IP. Look at the age of your competitor's IP. Is it new or about to expire? You should also identify IP of your suppliers, your distributors, and even your clients. For example, does your manufacturer or distributor have a trademark similar to yours? In what countries? How do clients use your IP? IP landscaping can give you an indication of future development, since filing a patent is often done early in the development. This means that you can look in databases to learn about innovations long before they enter the marketplace. Searching and analyzing IP can be complex, so it may be very wise to seek the help of an IP agent or other experienced professional. The CIPO webpage has a search tool to help you find qualified help with this task. Let's look at some of the sample sources for doing an external IP audit in the cleantech industry. By searching in databases, you're likely to find similar and even competing technologies to yours. However, patent data doesn't give you a clear indication of the commercial status of the invention. The idea may be at a very early stage, dropped by the inventor, or it may be available for licensing. The external IP audit may mean that you find something that you need to strengthen your own IP position. University websites are good places to look for technologies available for licensing. Another source is CIPO Green. This is a one-stop shop for clean technologies at all stages of development that are available for license, collaboration, joint venture, and sale. It's an interactive online marketplace that promotes innovation and the diffusion of green technologies. This network facilitates commercial relationships and transactions by connecting green technology providers and seekers for a wide range of technologies and players in the green tech innovation value chain. Technology providers, seekers, and partners can join CIPO Green, and there is no registration fee. So wait, does this mean that these technologies are available free of charge? No. If you're a technology provider, CIPO Green is like a free marketing tool. All technologies on CIPO Green remain the property of the right holders, and it's up to the right holder and the collaborating parties to structure agreements in the manner they feel is most appropriate and effective. A bit closer to home, we have Explore IP, Canada's public sector patent ecosystem. As I mentioned before, many universities have web pages where available technologies are listed along with short descriptions about the technology. On Explore IP, you will find over 3,000 inventions from both universities and additional public sector institutions such as the National Research Council, Natural Resources Canada, National Defence, and more. CIPO and other public institutions sometimes publish IP landscape reports. For cleantech, the reports Patented Inventions in Climate Change Mitigation Technologies, as well as the Patent Landscape Report for Shale Oil and Gas, can help you identify some of the main players and technologies and inventors in these industries. Look online for other publications from other IP offices, researchers, and so on. As I mentioned before, the external IP audit can help you understand the top trends, draw patent insights to rely on. For example, in Canada, patent analysis in 2016 indicated that over 3/4 of clean tech patents focus on advanced materials, energy efficiency, energy storage, biofuels and biochemicals, fuel cells and hydrogen, and transportation. If you are in these sectors, you will note that there are more patents and thus less freedom to operate and maybe more trade secrets. It's important to note that multinationals are the top patent holders in Canada. This suggests an IP strategy may include a review of multinationals in a business competitive environment. In addition to having multinational companies in our domestic IP scenery, consider where Canadian inventors may go. These graphs of the top 3 filing destinations provide a window into Canadian IP filing activity abroad. In 2017, Canada's top 3 filing destinations remain the US, the European Patent Office (EPO), and China. 81% of Canadian patent applications abroad were made in these countries. Patent filing abroad has been the driver of growth in global filings by Canadians since 2006. The United States remained the main partner for most Canadian businesses. Trademark applications abroad by Canadians have grown by 66% since 2008. Since then, Canadian trademark applications to China has increased by over 260%. We see faster growth in applications to countries outside North America, highlighting the decision of Canadian business to expand their international markets. Canadian filed over 1,400 industrial design applications abroad in 2017. International filings abroad by Canadians are up by 19% since 2008. Let's look at the IP landscape of clean tech inventions in US and China. These bar charts show the relative share of U.S. clean tech patents for certain technologies during 2011 to 2016. Transportation, advanced green materials, and energy efficiency technologies had almost 20% share, almost 2/3 of all clean tech patents during this period. A look at the annual change in the decade leading up to 2011, we see that the share of almost all of these technologies increased each year. In more recent years, however, we can see from the rightmost bar chart that the annual increase has reduced for many technologies. The exceptions include geothermal, nuclear, energy storage, conventional fuel applications, and bioenergy, where the IP activity is increasing. An IP audit does not only include IP. IP data is also often reflective of supporting factors in the innovation system, such as federal investment and policy direction. For example, solar trends were up in the past due to large government investments globally, but this is slowing somewhat now that investments or subsidies may be slowing or changing where they are coming from, such as a shift in government investments from Europe to China in the past decade, and IP trends will mirror this. As we saw earlier, China is one of the top filing destinations for Canadian patents, trademarks, and industrial designs. Businesses should consider that the global trend of patent filings in the cleantech space is driven by Chinese companies. Over the last 15 years, over 40% of inventions relating to climate, capture, and mitigation technologies were owned by China and are growing at a much faster rate than the rest of the world. The line chart shows patent activity for carbon capture mitigation technologies. In this chart, we see that recently, over 85% of patents are in China. For Canadian businesses, this suggests that if your IP strategy includes expansion, such as production, assembly, or sales in China, you may face additional IP risks not seen in other countries, and that this topic should be analyzed. So, as we have just seen, if you're expanding your cleantech globally, you may need to use different strategies. In Canada, some sectors have more IP than others, and many IP rights are held by foreign companies. In China, the patent landscape is crowded and driven by exceptional growth by local companies. In the US, in addition to increased patent activities in some sectors, you may learn which multinationals have the majority IP ownership. These are just some simple examples of the kind of sources and insights you will uncover as you explore the IP landscape around you. IP landscape are often complex as they focus on not only a snapshot of the industry leaders, but also innovation dynamics, such as who's licensing from who, where are the inventors, and how are they paid. They also look at trends and may capture some possible future scenarios that may impact your business. Another important area identified as a gap in the clean tech industry is the lack of standards. Having standardized ways of testing things and a common language and measure to gauge performance can have an immense impact on new industries. There are several ways to leverage from standards. If they exist in your industry, you can make sure your invention complies with the standards and illustrate this with a relevant certification mark. If standards are missing, you can reach out to the Standards Council of Canada to learn more about how standards can be created. There are examples where businesses have contributed to new standards just to be able to illustrate and distinguish their product's performance. In some industries, market leaders have also managed to include their patents in standards, making them standard essential patents. As you analyze the IP landscape around you, make sure you're aware of any existing and potential standards and how these may impact your business. The next step is to use your analysis to define gaps and opportunities in how you will use IP to achieve your business goals. In this step, you analyze and determine if you have sufficient IP protection to meet your business goals, or if you need to acquire additional rights. It may be useful to take help from the team that helped you with the internal audit to analyze if you can develop IP internally, or if you should get help by someone else. Define the gaps that prevent you from achieving your business objectives, and for each gap, formulate actions. Maybe there is a suitable technology available for licensing, or maybe you have identified a possible partnership to co-develop a more complete solution to reach a bigger market. In many cases, your action will depend on available funds. In Canada, the following organizations may be able to assist you to identify and secure funding for your innovation. The Clean Tech Growth Hub helps companies and researchers pursuing clean technology projects identify the federal programs and navigate the federal funding landscape. Participating federal governments and agencies in the Clean Tech Hub include the Business Development Bank of Canada, BDC. They help high-potential clean tech firms expand by providing them the capital they need to hire new staff, develop products, support sales, and scale up and compete globally. Sustainable Development Technologies Canada, SDTC, funds projects that support Canadian small to medium enterprises advancing innovative technologies that are pre-commercial and have the potential to demonstrate significant and quantifiable environmental and economic benefits. Export Development Canada, EDC, helps Canadian export-ready companies by providing financial solutions, risk protection, and market knowledge and access to global contacts to get the technology into new markets. www.innovation.canada.ca is also a useful portal to identify possible funding sources for your innovation. Step 4 in developing your IP strategy is mostly about making decisions on how you will bridge the gap and approach the opportunities you discovered earlier. Your approach will depend on what type of strategy you take. For example, some companies have a business goal to reach market leadership. They file for and enforce their IP rights to block competitor growth. Other companies take a more defensive approach and carefully analyze the IP landscape to make sure that they minimize the risk of infringing on anyone else's IP rights. For companies not intending to undertake their own manufacturing and sales, IP is an effective tool to expand business through licensing to others. For example, a company could make sure the invention is protected in all key markets and then use different industrial designs or trademarks to license an invention for different applications. Finally, IP can be a valuable tool to increase the valuation of a business entity. Solid IP rights are often important factors to investors when they do risk analysis of mergers, acquisitions, and funding projects. IP can also be an important tool to raise capital. As you think about the tactics in your IP strategy, take note of what kind of strategy your competitors have. The kind of strategy you have is also an important consideration for how you manage public relations. One of the actions in your IP strategy may be to file for more patents. So here I'd like to remind you of the expedited process that CIPO has for applications relating to cleantech. This service is intended to assist in reducing the time it takes for patent cleantech inventions, enabling businesses to bring them to market more rapidly. As I was mentioning risk and getting funding earlier, it could also be worth considering the expedited process to get a faster decision on whether or not your invention is useful, novel, and non-obvious. This means that you have a space to play in. The expedited process also offers a free gateway to failing fast, so that if you can't patent your invention, you will know this fast and be able to steer your efforts into new areas quickly. To take advantage of an expedited examination, submit a written request and declaration as indicated on the screen. You have now reached the step when your IP strategy will come into action. It is time to implement the strategy. While the strategy is built on informed decision-making, an important part of implementing the strategy will depend on internal routines, frameworks, rules, and policies. For example, if you have a strategy to keep some processes and data as trade secrets, employees will need to know what these are and how to deal with them. You may also need to assure that agreements for licensing and sharing IP information are in place and that they reflect the strategy you have in mind. For example, you may have decided to extend the protection of your trademarks into other countries, and that licensing agreements reflect the scope and limitations on how that trademark can be used. You may also need to make sure that confidentiality agreement and the sharing of IP information are aligned. Finally, you should consider the form of enforcement strategies you will require. Enforcement of IP rights is the responsibility of the IP holder, not the IP office. How will you monitor the market and competition? If you detect infringement, do you know what to do? As you have seen, an IP strategy is a multifaceted plan requiring business, technology, market, and legal expertise. These considerations and many more are available on our website, where you can build your own IP strategy guide based on where your business is at and what you're trying to do. Go to www.canada.ca/IP for business and look for the IP Strategy Assessment in the IP Academy section. The last step in developing an IP strategy is really about commitment. Many businesses have an invention, they apply for a patent with an idea on where to file, and then head back to business as usual. This is what some IP strategists refer to as file and forget, and can result in irreversible trajectory of your business. These days, the rate of invention and technology adoption are changing fast, so your IP strategy will need constant fine-tuning. It's a living plan, reflecting how you will protect and use your ideas to adapt to the changing IP landscape around you. Make sure you always have an IP strategy that is relevant to your business goals. In this section, I will highlight some of the specific IP considerations based on the typical actions taken as a product or service is discovered, developed, and finally reaches a market. As R&D is often done in a collaborative environment, we are assuming that there are several parties involved in these activities. As a general guideline, we are referring to something called technology readiness levels. This is a common way to estimate and explain how close an idea is to reach a market. The idea starts off at level 1, in which surrounding principles for something are observed. A concept is then developed, 2, and illustrated at level 3. The concept is then validated in the lab, 4, in a simulated environment, 5, before it is demonstrated, 6. During the final stages, the prototype is demonstrated in an operational environment, 7. Tested, qualified, or certified. 8. Before it can finally be deployed in the real world. 9. In the early stages, it's important that inventors and sponsors have established an IP culture. People should be informed and aware of IP ownership, strategies, and plans. Define background IP at the start. Before signing any collaboration agreement and alike, parties should identify and define what IP they already own and how this background IP will be shared during and after the collaboration. Manage disclosures. All parties involved in the collaboration should be aware of what they can disclose to each other and to external parties. For example, if academic researchers are contributing, there may be time or other limitations on how information, discoveries, etc., can be published or shared with others. Agree on ownership of potential new IP. Just like it's important to define existing background IP, a collaboration should also be clear on who will own any potential arising IP. Will it be shared? Who can commercialize it? What if there's an accidental discovery, unrelated technology but still valuable? Who can file, license, and so on? Define the novel, unique aspects of invention as soon as concepts are proved to work. This is important information for the next phases. As an invention is validated and can be demonstrated, use the novel aspects of the invention to conduct various searches such as patentability, freedom to operate, trademark registrability searches, especially before investing more resources. File for IP rights. Remember, IP is territorial. Ensure that your plan includes IP protection in potential foreign markets. Also secure rights to use dependent IP. Using others' inventions, even in a research setting, can be risky, especially if your demonstration for further funding depend on these related IP rights. Make sure you have secured the rights to use the related IP through licensing or other contracts. Finally, as your project is getting closer to the market, you'll probably consider manufacturing, sourcing of components, services, and other parts in order to sell your invention. This is why you need to include your partners in your IP strategy. In many cases, the prototype can be improved or changed a little so it can be smaller, lighter, or easier to manufacture. So, watch for improvements or follow-on IP. Think about these improvements as new IP, so make sure you already have defined rules for the use and ownership of background IP, foreground IP, future improvements, etc. in, for instance, joint venture R&D or outsourcing of manufacturing. Finally, consider strengthening your IP position through multiple forms of IP. For example, you may protect the design, additional trademarks, training manuals, software, or other companion products to your solution. Also, don't forget the enforcement. Continue to monitor your existing IP rights. As your application is published, be aware of copycats. Pay special attention to those citing your invention in publications or patent applications. The Canadian Intellectual Property Office has free resources that can help you take the most advantage of your intellectual property. To learn more about IP strategy, go to www.canada.ca/IP for Business, select IP Academy, and then plan your IP strategy. Here, you can generate a tailored guide with information on what to consider when developing your IP strategy. Under our Education, Tools and Resources, we also have a fact sheet about clean technologies and IP. Here you'll find more information about WIPO Green and the expedited patent application process. The IP Toolkit also contains guidelines on hiring an IP professional, the Intellectual Property Inventory Checklist, and our country guidelines for doing IP business abroad. Thank you for tuning in to our webinar about clean tech and intellectual property. Contact us if you're looking for more information on how you can use intellectual property in your business.